Abortion providers in South Carolina say they've returned to providing services for patients beyond 6 weeks of pregnancy for now. State Supreme Court temporarily blocked the ban until they make a ruling. Our Jason Raven breaks down the latest in the legal battle.
There's a possibility the state Supreme Court could hear arguments in this case as soon as next month. But for now, South Carolina's 6-week abortion ban remains temporarily blocked due to a unanimous order from the 5 justices. We first told you about the lawsuit filed by Planned Parenthood, South Atlantic, and others last month challenging the state's fetal heartbeat law. They argue the right to privacy, added to the state constitution in the 1970s, extends to bodily autonomy. The state and others defending the ban say the right shouldn't apply to abortions and was put in to prevent search and seizure.
Because of the timing, Roe v. Wade sort of took away all of the litigation about abortion and made it kind of a federal issue. So that this statute has not been tested within the context of abortion because it didn't need to be.
A state judge opted to send this case to the state Supreme Court last month, and this week the Supreme Court granted a temporary injunction or block while they decide on its constitutionality. Now, we spoke with Susan Dunn. She's an attorney who's been practicing in South Carolina since 1977, and she says the granting of this block does not give an indication on the Supreme Court's final ruling. Now, Dunn says there are 2 ways how the court could interpret this law.
They'll look at how other states have interpreted their rights to privacy that may have been adopted at similar times. And almost every state that has adopted in a modern constitution a right to privacy, when that state right has been tested in connection with abortion, the state court has held that the bodily autonomy that has to be included in the right of privacy would include the right to bodily autonomy, at least during the early part of pregnancy.
No date has been set on when the Supreme Court could listen to oral arguments. In Columbia, Jason Raven, 7 News.
You want to read the full order from the Supreme Court in its entirety? We posted it for you at WSPA.com.